And thank you very much, Bo, and thanks everyone for attending. A small group is always a good group, but I must say, who would have thought 12 months ago that that we'd be, that we'd be on Zoom or Microsoft Teams or WebEx, and we'd be forced to have these sorts of things that ready to go. But anyway, that's the way it is in a modern society. And of course, based in Melbourne, we're almost lepers down here. I think no other state is particularly welcoming of Victorians at the moment, so we've got to do all our stuff online. But anyway, thanks very much. I assume everyone can hear me okay. And good. And if you can, I assume everyone can see that the PowerPoint slides or the PowerPoint slide that's up on the screen. And you don't have to worry about making notes. If anyone wants a copy of this PowerPoint presentation, you can have it. And I'll make sure it's circulated through Bo or through Peter in the ACT. I thought the context tonight would be a good context to talk about some of the work that I do in the legal area. And even though I have a law degree and a master's in criminology and a PhD in criminology, but one of the many things that I do is I spend a lot of time working with lawyers. And I don't practice as a lawyer. I'm the advocate that assists lawyers in the courts. And effectively what I do is if someone is seriously damaged in the workplace, because most of my cases are typically personal injuries type of cases. So if someone gets seriously damaged or killed and there's civil litigation that flows, then quite often if it's a security or safety, operational security or safety type of case, then quite often I'll have the lawyers chasing me. There wouldn't be a weekday go by where I wouldn't speak to a lawyer from around Australia. So the phone runs hot. Doesn't mean I always take a case on. Sometimes I might be conflicted if I've done work for a particular, for an organisation, and someone gets hurt. Say, for example, at a casino, if I've done work for a casino and someone gets hurt at that casino, well, then typically I couldn't get involved either way. So I'd be conflicted in those sorts of circumstances. But the reality is, I suppose, I've done over 500 cases. I can safely say to you that there's a lot of common themes that keep coming through. And what I thought I'd do tonight is take you through some of the issues and some of the risks associated with being a security consultant and providing advice, and how that advice maybe, could be subject to litigation of itself if the advice is wrong, or if it's reckless, or it's negligent, or it's inaccurate to some serious degree. So I thought I'd just touch on that for a start. And then I thought this is one of these sessions where we don't learn everything out of a book, but we learn a lot of things from litigation. So I thought I'd take you through about 4 or 5 cases that I've been involved in. They're cases that I think will be of interest to you. And of course, as security consultants, as we all know, a system of security or an operational system of security is really developed from a risk assessment. And we're seeing that quite clearly these days. I don't know if you've been monitoring the hotel quarantine inquiry. The security industry is not coming out of this glowing, but as I said in a recent radio interview, you always need to remember one thing, and that is security staff will only work to the system to which they've been introduced. So the system comes from a risk assessment. There will be, some approval of the operational system. There will be management. There will be supervisors. There will be contracts signed, etc. And then, of course, the evidence that we see operationally is security guards or crowd controllers or investigators or whoever else working on the ground. So effectively, I'll just take you through what I think is a reasonable approach to how we could minimise risk, but also the risks that might be confronted in the context of people providing advice in serious circumstances, of course. So the outline is on this slide here to discuss litigation and responsibilities of duty holders, but remember the context is for those who are providing security or safety related advice. Explore the connection between risk-related advice and litigation. I'll take you through some of those cases, as I said, and then I'll take you through the themes. And the themes won't be surprising to experienced security personnel, but sometimes it's good to put the context in place to build the framework and say, okay, here are the themes, and this is the way that these themes, these risk themes, are managed. Can I just say, my experience over 500 plus cases, I'm probably about 60% plaintiffs and about 40% defence at this stage. So in other words, if someone gets injured and they sue and they go to Slater and Gordon, or in the ACT, they might go to Bloomers, which is one of your bigger law firms in the ACT, but they might go to Slater and Gordon or any of the other ambulance chasers, as sometimes they're referred to. That's where a plaintiff goes. So a person who's injured, they're the plaintiff. The defence will normally be the organisation. It might be a worker in an organisation. It might be the insurance company that's joined as a co-defendant in those cases. And I'll show you how that works shortly. So about 60% plaintiff and about 40% defence, which is interesting because I come across the same barristers all the time. Now, whether it's a senior counsel or an SC or a QC, or whether it's a barrister that specialises in personal injuries types of cases, doesn't matter what state or what territory I'm in, I come across the same ones all the time because they specialise in that area. So anyway, so I'll just move forward to the next slide. And as you know, this is all about you and the ACT, security consultants are licensed under the Act in the ACT and subordinate legislation, which is the regulations, of course. So the Section 7 provides for licensing. Section 13 says, you know, what the function is of a security consultant. Regulation 8 mandates minimum competency levels at Certificate 4 under the AQF, the Australian Qualifications Framework. And commonly, security consultants are an external resource rather than employed in-house commonly. That's not to say, of course, all consultants are external, but most of them seem to be. So just out of interest, I suppose, just before I'll just go back, in Victoria, for example, we have a similar licensing system, but where security advisors, you know, the persons who set up the systems and provide advice about the systems in Victoria, do not have a license. They're actually registered. So there's still a probity check, but the competency levels of security advisors in Victoria is very different because we don't have minimum requirements. New South Wales, Queensland, ACT, of course, do in the other jurisdictions. But Victoria hasn't quite got there, which raises that issue about national licensing and national competency standards, because we still tend to be a bit different as we jump across borders or jurisdictions. But anyway, that's a discussion we can have another time. So I think it's pretty fair to say, if you look at the role of the security consultant, you know, it's well accepted as a security resource, whether it's a government client engaging you, whether it's a private enterprise, whether it's a multinational or whatever it may be, might be a hospital. You know, security consultants are well accepted as a security resource. I left Victoria Police back in 1990, so I've been around for 30 years. And I actually wrote the first approved security guard, crowd control, private investigator training courses in Victoria. And 40,000 participants later, I sold my company because we had 8 degrees and about 50 vocational courses, and they were all public safety types of courses. But interestingly enough, a security consultant back in 1990 was seen very differently as a security consultant, you know, in 2020, as I'm sure those who have got experience over a number of years in the industry have seen, you know, the emergence of better, more focused, more competent security consultants. And we certainly see it, as you would see in the ASIS chapter in the ACT. We certainly see it in Victoria as well, and other jurisdictions that I've travelled to. Of course, they provide independent specialist advice. They bring broad knowledge, usually across industry sectors. The good thing is that security consultants, you know, if ever you're marketing your services, one of the big things you always bring in is cross-sector and emerging industry trends and products, you know, whether it's biometrics, system integration, staff development, training, etc. And of course, security consultants can assist with tenders for security services. I think at this stage, I've probably helped or worked with 10 different industry or across 10 different industry sectors as their independent expert. And even though they call me an expert, no one's an expert, as we all know, because we never stop learning. But as their independent expert, when tenders are out there, and then of course I sit with the panel and talk about what should be in place from a compliance, training, induction, supervisory type of position. Anyway, so security consultants, I assume all of us who are attending here consult in one level or one way or another. So what are the risks for us as consultants? And of course, one of the things that when I had my former training company that I sold to a global education provider, Navitas Limited, which is in the ASX 200, when I was providing advice at the same time I owned the Australian Institute of Public Safety, and we'd have 4,000 students coming through a year. We didn't go to the international market, but we were a higher education provider, so we were offering degrees. We're offering degrees as well as 50 vocational courses, and we were training Victoria Police and the AFP and the old customs, as they were known in those days, hospitals, corrections. We were right across a whole lot of areas. But I'm providing advice. So here I am sitting there thinking, well, I'm providing advice that was probably about 2% of the income of the Australian Institute of Public Safety. But I'm thinking, if ever I provide advice and something goes wrong, someone gets hurt, whether I'm wrong, whether the advice was wrong or not, and I become a defendant, then the Australian Institute of Public Safety becomes a defendant. So I separated the corporate structures. So I had a separate consulting proprietary limited company that was insured separately. It was effectively a separate entity because a proprietary limited company, as I'm sure you're all aware, it's a separate legal entity. So it can sue, it can be sued. So rather than having the Australian Institute of Public Safety, my education, with 4,000 people coming through its doors each year, sued because of a small piece of advice that I may have given, whether it was right or wrong, is different. So I would suggest to all of you, if you haven't considered your corporate structure, seriously do, because advice is a high risk area, whereas you might be doing other things like training, education, etc., which is not so much a high risk area as we know. So anyway, exercising common sense. Make sure that there's adequate insurance, so professional indemnity, of course, and public liability would be the other. Then there'll be other compliance requirements, but certainly make sure there's adequate insurance coverage. Make sure that any work that you actually provide is work within the scope of your expertise, because if ever there's an issue, I think I can safely say in Australia, I'm aware of 2 TAFEs and 1 private RTO that have been sued for negligent training. I'm aware of no cases in Australia at the moment, but I did write a security consultant out of a litigation in a case a couple of years ago. But I'm not aware of any security consultant or safety consultant at this stage that's been sued based upon the advice they've been given. But if you look to the United States and to the UK, it's common. It's common. When someone provides advice, it is common. I was recently involved in a case that involved McDonald's, and McDonald's have got their own in-house. They've got 2 in-house risk assessors that go around the country and conduct risk assessments. And their risk assessments quite often are based upon the local environment, the design, the levels of activity, the hours of trading, the size of the store, and then drill down into those pure security types of considerations. And interestingly enough, some of the advice that was given by one of those consultants was questionable. But as I was saying to the lawyers, let's not get distracted by questionable advice. There's still enough here to run the case and achieve a successful outcome, which is what actually happened, because the case still ran. It settled after day 1. But at the end of the day, it's something we need to be very much aware of. Is the advice we're giving within the scope of our expertise, and can we actually show it was in the scope of our expertise if ever we're taking the task? Are there suitable contract arrangements in place between the parties? What exclusions apply? If cyber security is not part of, say, a security review of a hospital, make that very clear. Make sure that the IT, and relevant areas that might be attached to cyber security are actually excluded within the contract, so there's no mistake. If you're subcontracting any part, whether it's full or partial, that should be clearly identified as part of the scope of works. So, for example, if someone else has better knowledge about CCTV systems or alarm systems or duress systems or whatever it may be, and you're going to subcontract part of a risk assessment in particular out, then that should be clearly shown. Are actual or potential conflicts identified? Nothing's worse. I've been, Victoria's biggest hospital network is Alfred Health. And Alfred Health is the Alfred Hospital, Caulfield and Sandringham hospitals, and a number of outreach services they provide, you know, around the southeastern suburbs of Melbourne. And one of the considerations would be, are there any actual potential conflicts identified through conducting a risk assessment or providing advice for one hospital when you've actually provided advice at, say, a competitor's hospital? And as much as, you know, you wouldn't necessarily be fully conflicted, there may be an issue that needs to be considered, especially if there's a change of manager from one to the other. You're now working for the manager who already knows you. It just, you know, it's just an area that needs to be considered as part of work. And then how is reporting to occur? And of course, those of us, and I assume that'll be all of us, that are aware of QA, quality assurance requirements, if it's not written, it didn't happen. So we need to ensure that whatever we're reporting fully, accurately, and it can be justified if ever we're taken to task. So the next slide talks about advice and litigation. And when we talk about advice, where security consultants, SC as security consultants, has formed legal relations, then potential risks can involve negligence. So in other words, a breach of the duty of care. We've all heard about that time and time again, and I'll elaborate shortly about that. It could be negligent misstatement causing economic loss. So if someone relies on serious information provided by one of us and they suffer an economic loss, and sometimes they're substantial, these economic losses, that can expose us. It might be alleged to be a breach of contract, that we didn't do what we said we were going to do once we'd formed legal relations. It could be a breach of consumer law. So normally it's misleading or deceptive, or likely to mislead or deceptive conduct, normally in obtaining work, and then the way that work's performed. And then the breach of other laws such as work health and safety. And as we know, the principles of work health and safety take us into a whole realm of relevant considerations. And if I said to you, so what's the difference between a security issue and a safety issue? It's a question that yeah, many people out there, because we provide advice, sometimes interchangeably. Security and safety are used interchangeably, especially if you're talking about occupational violence and aggression. You know, it's a person that loses the plot in, say, the emergency department of your local hospital. And, you know, people come from everywhere, and we know that we have, you know, response teams, code grey teams or similar who would respond. Of course, you know, someone gets hurt. The question might be, well, is that a breach of workplace health and safety? Is it a security related issue? Is it both? So we need to certainly define what security is and what safety might be in the context of those considerations. And of course, whatever the relationship is down the bottom of the slide, it implies that there is a duty to exercise reasonable care. And when I used to teach in this area, I used to say to all my criminal law students and my legal process students, understand one thing: negligence actions are not an exercise in perfection, they're an exercise in reasonableness. Did we provide reasonable advice, which may not have been perfect advice in the circumstances? And that's something we need to think about in the way that we go about our work. So negligence is there. I'm not going to read the slide to you, but you'll see there's four elements that need to be proven in any negligence action. And that is, you know, that there is a duty of care owed for a start, that there was a breach of that duty. In other words, the defendant in the circumstances did not meet the standard of care which a reasonable person would have, which is subjective analysis, of course. That the plaintiff has suffered injury or loss which a reasonable person would have expected to foresee. And then the main issue here is that the damage was caused by the breach of the duty, in other words, causation. And I'll take you through a case shortly, but one of the leading cases out there is what's called Adeel's Palace. And that case went to the High Court, and that was a case that I was involved in, and it's a leading case on causation in Australia. And if you spoke to any lawyers out there, most of them would know Adeel's Palace backwards, because, as I said, it's a leading case. It went from the New South Wales Supreme Court to the New South Wales Court of Appeal to the High Court, and therefore it becomes a binding precedent on all inferior courts. But I'll take you through that case, because it's actually a case, as I said, I was involved in, where two people got shot, and it's an interesting case. So the parties to litigation, and this is civil litigation, so we're not talking about criminal law where there's a higher standard of proof beyond reasonable doubt. We're talking about civil litigation. In other words, the balance of probabilities, or what's sometimes known as the 51% test. So a plaintiff gets damaged, they initiate proceedings. And when I say damage, it might be physical damage, it might be nervous shock, post-traumatic stress disorder, and they claim against the defendant. And if the defendant intends to defend, well, they enter a defence, which is in writing, but they can also initiate a cross-claim. And cross-claims can sometimes be against the plaintiff themselves, sometimes involving a third party. And classically, some of the cases that you would relate to, I think, are you've got licensed premises and you've got a contract security firm providing the crowd controllers at those licensed premises. So they're not employees of the hotel or the licensed premises, they're employed by a contract security firm. So quite often, if someone gets damaged at a hotel, and they might sue the hotel, or the hotel might look to their security provider and say, well, you guys didn't react reasonably, or you overreacted, or you underreacted, or whatever it may be in the circumstances. It's not uncommon these days for there to be cross claims in litigation. Normally it'll be the employer, and then it might be who's provided advice, but more likely not, it'll be the provider of security services. That's a lot of the cases that I've been involved in. If there is a cross claim, then the defendant becomes known as the cross claimant and the other parties as cross defendants. So it gets a little bit confusing, but that's a structure, and you can maybe ponder that later on. So what does a typical system of security look like? And I think it's fair to say this would be the standard approach. In other words, there should always be a security policy of the organisation. There should be a risk assessment at some stage, preferably before things get to establish. As we know, the Australian standard for guards and patrols, 4421, talks about that there should be a risk assessment before we start work at a site. But of course, that doesn't happen in the practical world always. There should be a security management plan, which is really used as an induction tool for staff, of all staff, security staff, non-security staff, so they understand what the security intentions are for this particular site or property or campus, whatever it may be. Then there'll be physical and personnel protection, so physical hardware and technology, personnel being people who are dedicated security staff, supervisors, down to operational staff, but also other guardians. And interestingly enough, I was addressing a law firm in Melbourne last year, and there were about 60 lawyers there who were all involved in personal injuries types of cases. And I made the comment about the receptionist is actually one of your better guardians. And of course, in the next minute, it led to a conversation for about 10 minutes about what's a guardian and what should be the competencies of guardians and what they should do. And of course, the receptionist, you would expect to do nothing else other than observe, report, hit the duress button under the counter. There'd be a organised response, etc., if there was that type of issue. But certainly, personnel is not just security personnel, and that gets lost a lot of the time in risk assessments. There should be standard operating procedures. And as we know, whether we call them guidelines, protocols, but standard operating procedures, they remove, and they should remove, the exercise of discretion of individuals in most circumstances. Not all, because we can never write a procedure for everything. But at the end of the day, the exercise of discretion by individuals within a system of security is your weakest part of that whole system on that slide. And of course, there should be a review of the system post-incident, after a hot debrief, sometimes down the track, as well as, say, an annual or a biannual review. So that's typically what a system looks like. And then if you look at the next one, pardon me, if you look at the next slide, the assets to be protected, the existing security system, what's the threat assessment, the vulnerability analysis, put it all together with an assessment analysis, and then you've got that system that I had on the other slide, so on the previous slide, so from 6 to 10. And that's really, I suppose, the process. If I was looking at a system of security that applied, and of course, the first thing when I'm engaged by lawyers is I say, what was the system that the person who got injured was inducted into if they were an employee of an organisation? So, for example, let's say Canberra Hospital have a violent incident in their reception area, in their ED area, say, staff respond, one of those staff gets seriously damaged, that staff goes and often sees Bloomers or one of the other law firms and says, I was poorly trained, we didn't have operating procedures, we were short that night, that's why I got hurt. I wasn't trained, I hadn't attended training for 4 years, whatever they're saying. Well, effectively from there, my first question would be, so I need to see the system that they were actually inducted into. What were they inducted into? What were they, how did the system work? What are the records to prove this? Because at the end of the day, once civil actions start between the defence, the defendant and the plaintiff, what happens is the plaintiff makes their allegations, the defendant, if they're going to defend it, responds to those allegations, and of course they're exchanging information, which is called interrogatories. So it's exchanging questions and answers between the parties, like people standing up in court giving evidence, but it's an exchange of information on paper between the lawyers. So effectively, during the exchange of information, there might be an assertion by the defence, oh, we did train this person. We trained them last year. They've attended 4 different sessions. They've attended, workshop meetings. They've attended this. We've got operating procedures. The next question that would come from me through the lawyers is, let's discover the records to prove what you're saying is correct. Let's look at the training materials. Let's look at the attendance list. Let's look at the times of training. Let's look at who trained these people. What's their competency levels? Because really what you're looking for is, was this a reasonable system or was it not? If it was a reasonable system, I would say to the lawyers at that stage, give it away. I don't think you're going to get there. Or I might say, in part, you're strong here, but you're weak here, just so that the barristers who are going to argue this in court have got that information behind them. But typically, that's the approach that you'll commonly see that I would be looking for. So elements of an effective system would be developed from a risk assessment, aligned with Australian standards and common industry practice, because there's not always an Australian standard, as we know, out there, that it's formal. In other words, it's documented. There's plenty of evidence to show what the elements were and how it was all, operationalised. That involves induction and training, that the system was tested at some stage. Gone are the days in high risk activity where online training of people in, say, occupational violence and aggression is acceptable, because it's not, as we know. If you're going to teach someone how to be a good conflict manager, that's all good. You can teach bits and pieces of that online, the underpinning theory. But how can you teach someone to break and escape and move away from a violent person who's invading body space, grabbing weapons, throwing things around? How can you teach that online? So at the end of the day, competency is one of those considerations that needs to be addressed, but tested appropriately and realistically and regularly reviewed. I had a case out of Queensland, it'd be 5-6 years ago now, where a worker in a hospital got the living daylights belted out of him. And when you looked at the CCTV vision, and it was in a psych-related area, which is high risk, as we know, mental health. And he got the living daylights out of him. And I'm looking at the CCTV and I'm thinking, this guy had no idea what to do. He didn't know where to stand. He didn't know anything about, reactionary gaps, about moving from an inside to an outside position. He didn't know how to break and escape when he was grabbed. And it was interesting because when the lawyers went back to this particular healthcare provider, they settled very quickly. Because once the questions were asked, they could see that they fell down. It wasn't a reasonable system, and part of the unreasonableness of it was a person who was going to be part of a code grey response team was taught everything he needed to know. It was a he in this case was taught everything he needed to know online. And as I said, well, you just can't do that. You can't do that. Okay, so maybe to make the point here. Is let's have a look at 4 cases. The first case is Adeel's Palace, which is where 2 people got shot in Sydney. The second one is the death of a worker, which is Chan against CPL Computer Parts. The third is Channel 10 down here in Melbourne had a major incident a number of years ago where Maria Sachanidis was seriously damaged. And the fourth one is Anastasiou, who was a security guard who sued Chubb Security. And you'll see as I take you through the cases, the differences between them. So the first one is Adeel's Palace, and in Adeel's Palace in 2002 on New Year's Eve, some of these cases take 10 to 12 years to actually be finalised, depending on the courts that they might go through. But in 2002, you can read through the points there. But there was a New Year's Eve party. It was a Lebanese Lebos. It was a Lebanese function, and there were about 400 people there, but it was a family function. So there were family members, husbands, wives, grandparents, there were children there, and it was in Punch Bowl. and it was on level 1 of this particular building. And there was one crowd controller who was down at the front door on the ground floor, and he was there just to ensure only invited guests or those who were authorised to enter entered. So there were about 400 people, and during the night, there were no security staff present at the time, only the crowd controller down at the street level, but he actually went home sick. I suspect, New Year's Eve, maybe he wasn't that sick, maybe he ended up somewhere else, but that's another story, and we don't have any evidence of that. But there were 2 male operators intervened on the dance floor incident and ejected a patron, Danny Abbas. Danny Abbas became the shooter. So I think from memory, there was people dancing, someone smoking, someone got burnt, someone didn't like it, and there was a bit of push and shove and a bit of a slap. And next minute, Danny Abbas gets ejected by the 2 managers, who virtually knew, if they didn't know everyone, they virtually knew just about everyone at this function. So Abbas left. He went down. What we didn't know was he went there. He went down and got a handgun out of his car and came back. And in front of hundreds of witnesses, we're talking 400 witnesses, he shot 2 patrons. One was involved in the fight and the other was a bystander. What he didn't realise first was the first guy he shot was a bystander, and then he's realised that he shot the wrong person. So he chased the offender, what he said was the assailant or the offender for him, into the kitchen. This plaintiff was on his knees begging for his life, and Danny Abbas comes up and shoots him in the chest. Both men survived, but the 2 patrons sued Adeel's Palace. So what would they say? They would say that you'd been negligent. Both plaintiffs were successful in the New South Wales Supreme Court and again in the New South Wales Court of Appeal. But the plaintiff argued through their lawyers, or the plaintiffs, I should say, argued through their lawyers, that if there'd been more security staff, that would have prevented the incident. Now, I was the expert, questionable, but I was the expert for Adeel's Palace. And there was a security consultant from New South Wales who was the expert for the plaintiffs. And he was saying if there'd been more security staff, it would have prevented the incident. We're talking about the guy going out, getting a gun and coming back and shooting in front of 400 witnesses. And I'm saying it was lucky the crowd controller who was down on the ground floor who went home was lucky he went home. Because if this guy's prepared to go out and get a gun and come back and shoot 2 people in front of 400 witnesses, it's lucky that crowd controller wasn't there, because he would have been unarmed and he might have been the first victim. And then there would have been subsequent victims as the guy came back in. So the way the case was argued and pleaded, the High Court found, amongst the other things, that the evidence did not show that more security staff would have prevented their injuries, and the High Court found for the defendant. So this is now the leading causation case, which really says, as I say to some of my students out there, this really says, just because someone gets hurt doesn't mean someone is strictly liable. It depends on the circumstances of the particular case. So that's the leading case, as I said, on causation. This next case is Chan against CPL Computer Parts. It's a very sad case because it involved the murder of a worker. So CPL Computer Parts operated in Notting Hill and West Melbourne down here in Victoria. They're about 20 kilometres apart between the 2 work sites. Joanne Zhang, who was the deceased, was employed by CPL and transported cash from West Melbourne to Notting Hill. So no armour guard, no cash in transit provider, effectively no risk assessment. Effectively, they just decided, well, you take this cash from this location in West Melbourne to Notting Hill, and you do it every day. Every worker in the place knew what the system of security was for cash. So on completion of work, Joanne Zhang on this particular day was stabbed a number of times outside the West Melbourne store by a fellow worker, Eric Pan. She actually went out the side door into the car park, which was an isolated car park, an unlit car park, but it wasn't quite dark, but it was dusk. There was no one around, and Pan just came up behind her and stabbed her because he was after the money. So Zhang was transporting on that day 9,000, but she had transported up to 25, 30,000 cash, but she had 9 grand that day. So after he stabbed her, he placed her in the boot of her car. He then drove around, he got to St Kilda, he parked the vehicle, he sat and listened, he admitted this to the homicide squad detectives later on. And whilst she cried for help and struggled, when she fell silent, he assumed she was dead. So he then went to the casino and was later arrested. He was subsequently convicted of murder, and Zhang's fiance, Chan, sued CPL. Breach of the duty of care, you know, the daily takings were typically between 3K and 20K. The system for cash handling was known by all employees. Everyone knew they had no security there effectively. No cameras, no alarms, no lighting, no signage, no time delay, none of that sort of stuff. Cash was transported daily, as I said before. Cash was transported at predictable or routine times. There was no risk assessment. There was a single page undated generic cash handling procedure. So note this, single page undated generic cash handling procedure. We don't even know whether that procedure was ever circulated to any of the workers at that particular site, including the deceased. So, and yet in my brief, as I'm preparing my expert report in this case, I noticed that WorkSafe, the Victorian Work Cover Authority, had actually conducted an assessment, and they said that the system of work and safety appeared reasonable because they had a cash handling procedure. Well, didn't I give it to them? so I said, if you think that that's a system, you know, anyway, cut a long story short, I actually, at this lawyers conference, I actually spoke about it. I didn't realise 2 WorkSafe people were there because no one told me. So I gave it to WorkSafe again at this presentation. And the next day I get a phone call from this WorkSafe manager who said, I know that you mightn't have known that I was actually there at that presentation yesterday. And now that you've explained what a system should look like, we agree with you. I thought, yeah, that's nice. It's a nice concession. But anyway, there were no security protections in the car park. There was no training in safety or cash handling strategies that we would say would be appropriate. And of course, they didn't want to argue it. When they saw all the information, the case was settled, a substantial amount that was settled for. The next case is Maria Sachanidis. And Maria Sachanidis was an in-house security guard at Channel 10 in South Yarra, at the Como building in South Yarra. So Maria was employed by Ten Security, which is one contract firm providing security services to Channel 10 television station, up on levels 4, I think, to about level 7 or 8 in those days. And then there was another security company, Delta Security, which secured Como Complex, which is a substantial commercial, retail and residential complex, and the car park. So you've got 2 different security firms working on the same property. About 4 a.m, an intoxicated and mentally deranged male entered Como, alleging to a security guard of Delta that he was a Channel 10 employee. So the guard down in the car park had no idea, but what he did was he escorted the male to Channel 10, where Maria Sachanidis was, and she actually confirmed he wasn't an employee. So then he's produced a knife, he's forced his way into areas of Channel 10 and caused substantial damage. He smashed the place up in multiple floors. It was only at that time, at about 4 a.m, there was like, you know, the manager, the production manager, and I think 3 or 4 staff on the various levels. So there was a Victorian Supreme Court civil trial. She claimed nervous shock. She wasn't physically damaged, but she was certainly rocked by the incident. And the incident went on for something like about 25 minutes before the police actually got there and could gain entry into the Channel 10 tenancy. So the issues that came out in that particular pre-trial discovery and interrogatories was there was no formal or informal agreement between the security firms. So you've got 2 security firms operating in the one complex, but there was no formal or informal agreement between them, which you might find surprising. There was no risk assessment for Como or the tenancy, the Channel 10 tenancy. There was no security plan or standard operating procedures in place. There was no strategy about screening people before entering the Channel 10 tenancy. And look, all of us know this stuff. There's some interesting people out there in our society. Some suffer mental illness, some are quite bizarre thinking, and unfortunately some of those people are attracted to TV personalities or those in the media. So at the end of the day, you know, television stations are always secured, as we know. There was no on-the-job training for security staff about managing difficult persons, in particular the person downstairs, and the court found for the plaintiff and Maria got a substantial payout in that particular case. The last case that I want to take you through is Mr. Anastasiou against Chubb Security. And this again was another sad case because Mr. Anastasiou had been a security guard at the Southgate shopping mall for a number of years. Everybody knew him. He was very popular, but unfortunately, there were deficiencies within the system that he was working within. So Chubb secured the mall, and PJ O'Brien operated a pub with it that effectively people entered and left the licensed premises into the shopping mall. So crowd controllers at PJ O'Brien ejected a male patron who then lingered outside the venue in the shopping mall. Mr. Anastasiou attempted, a security guard, about 55, I think he was in those days, he attempted to remove the male patron, and during a struggle, Mr. Anastasiou fell, resulting in significant permanent injury. So there was a Victorian Supreme Court civil trial. The parties wouldn't settle on this one. They decided to run it to trial, which is always a risk because at the end of the day, the civil standard is, as I said before, on the balance of probabilities, or what's called the 51% test, whereas criminal law is beyond reasonable doubt, sometimes referred to as a 99% test, if not higher. So the relevant issues that came out pre-trial and then during the trial actually gave evidence in this case. There was no documented agreement between Chubb and PJ O'Brien. There was no formalised risk assessment by either of the parties. There was an unwritten, in other words, a verbal understanding between the parties that PJ O'Brien would remove ejected patrons out of the mall. There was, so you'd expect the crowd controllers, if they got hold of someone and they're removing them or escorting them out, you'd expect them to escort them out of the pub and out of the mall, because these security guards are guards, they're retail guards, they're not crowd controllers. There were no instructions to Anastasiou or Chubb staff about dealing with intoxicated persons removed from PJ O'Brien's. There was no training about dealing with persons refusing to leave the complex, including how to physically eject if required by the PJ O'Brien rather than the Chubb guards. So, as I said, I gave evidence in this case. Mr. Justice K held, it's almost like he used my report as a checklist. Chubb did not train its staff appropriately for the task. So this is for the retail security guards, the shopping centre security guard. Chubb did not conduct a proper risk assessment of the work to be performed by Mr. Anastasiou and devise an appropriate work plan. There were no properly documented procedures in place to ensure PJ O'Brien's staff evicted patrons out of the mall, and the court accepted that Mr. Anastasiou had complained about this to his superior. This is another case where CCTV vision was actually shown in the Supreme Court in Victoria, and the judge said to me at one stage, so after seeing it, so what do you say about it? And I said, this just supports what I was saying about his lack of training. When this guy turned on the security guard didn't know what to do. He actually had his hands beside his waist all the way through, trying to talk to this guy, but he didn't have his hands up. He wasn't creating, a reactionary gap. He wasn't, seeking to strategically withdraw and move to an outside position. There was none of that sort of stuff occurring. So as I said, the sad thing was it just, the CCTV reinforces. So what I was saying, he won that case and again got a substantial payout. So what are the common themes that are coming through in all these cases? Well, the common themes are that each through discovery and interrogatories, in other words, that information that you get before a trial, it showed that there were informal systems in place. There was an absence of procedures, there was an absence of guidance materials, there were no security management plans. So they were informal rather than formal systems. They were very much weighted towards reactive systems because there wasn't too much about this is how we minimise risk. It's more about if someone loses the plot, this is what we do. If someone is highly intoxicated, this is what we do. Not about all the practices about minimising risk in the first place. So they were reactive rather than proactive systems. A good system has both built in. We try to prevent things, but if it all turns pear-shaped, then we still can react. But our first port of call, which is an exercise in common sense, is to try and anticipate what the problems will be and minimise them. There was poor system development overall. There were deficient risk assessments. In most cases, there were none, so if any. Failing to align with standards or common industry practice, deficient supervision or training, and little evidence to defend an action. And that's really the issue. There was little evidence to defend an action. So if you're a risk assessor looking at a particular workplace and you identify a number of risks, then how are we going to manage those risks and how are we going to certainly report those risks to ensure that we've at least discharged our duty and ensure that the client or the organisation is actually fully aware of what the incident, what the risks are and how they should be treated. So what is reasonable, and I think it's pretty fair to say in general terms, what's reasonable is basically a formal risk assessment conducted by a competent assessor, which is really number one. So remember when I talked about what's the risk to risk assessors or security consultants, and the risk is if we step outside of what our areas of expertise are, then we expose ourselves. So we've got to be a little bit careful. But at the end of the day, it doesn't mean that we can't bother to bring in some experts to assist us. If we're going to subcontract or rely on other information or other expertise, we should clearly define that. So formal risk assessment by a competent assessor, align with legislation, industry standards, or common industry practice where relevant. Can I say to you, I have never done an expert report where I haven't very methodically referred to all the relevant legislation, industry standards, and common industry practice. The reason being, I might lose credibility very quickly. If I'm standing in one of our higher courts giving expert evidence, and I'm virtually saying it's a great idea by Tony, I'm going to lose my credibility very quickly. So it's got to be where we possibly can. We align with legislation, industry standards, work-safe guidelines sometimes, common industry practice where there's an absence. Where there's a contractor, ensure clearly outlines the roles and responsibilities of the contractor in the work. Develop a formal system that focuses on prevention, not detection or reaction. We should note changing circumstances, industry trends, and industry responses. It wasn't that long ago, for some people that have got grey hair, it wasn't that long ago where domestic violence in a workplace hardly got noticed. Some of my bigger clients now, one of the issues that I always talk about is, so what would people do if there's 50 people in this workplace? Someone's going to separate from someone at some stage. What would people do if there's abusive telephone calls, if there's stalking, if there's an OVA, if there's an intervention, or I should say, issue, if there's an OVA type of incident in or around the workplace, what's everyone expected to do here? So it needs to be addressed as part of work health and safety. So ensure a robust induction, training and professional development strategies in place, monitor performance, identify any issues of concern, and review the system post-incident at regular intervals. Now, as I said, I've gone through this quickly. This PowerPoint, if you want a copy of it, you certainly are welcome to have a copy of it. If nothing else, I think the message that we get out of this is if we have formal systems in place and we act reasonably and cautiously, we minimise risk. And of course, I would say, and I've said it time and time again, the most important person in any system of work, system of safety, system of security is the person that assesses it. Because at the end of the day, people can only work to the system that has been introduced. So, our role as security consultants or assessors is paramount to everything else that follows along behind it. Okay, without taking a breath, I've spoken for nearly 50 minutes. Sorry it's taken so long.
Who's counting? Thank you so much.
Any questions?
Yeah, we do have a good question to start with. James has said he'd be interested to know your views on the common use of the run, hide and fight in regards to active assailant and the minimal training provided to staff.
It's a risk of itself, isn't it? It's one of those areas where, in particular, I mean, run, hide and fight comes up typically in critical infrastructure type of environments, but of course it can come up in any environment, as we know. I don't look, at the end of the day, to me, when we talk about run, hide, fight, and I think there's something else now, isn't there? There's a different approach: run, hide, and something else. Report. But at the end of the day, there's so many different considerations that are relevant, I suppose, to environment, design, staffing, potential weapons, areas to withdraw, etc., etc. I tend to think, though, if there's any guidelines and training, well, it's got to be better than nothing. But it's probably very much a generic answer to a generic question.
Oh, thanks. It's another follow-up to that one. There's a few good ones here. Another follow-up is, would the reasonableness of case law such as Adeel's Palace change as the common industry practices change? So 18 years later, active arm offender knowledge and procedures should be improved.
Yeah. And look, that's what happens. The common law, effectively, I mean, legislation is written, so we have legislation. The common law quite often evolves with interpretation of legislation. So very sadly, the common law sort of follows along behind legislative influences. And then there's got to be a case where you'd say, okay, Adeel's Palace, the facts of that case, if the next case become a binding precedent, remember, it's not hard to distinguish the facts of one case to the next. So therefore, the argument might be, well, Adeel's Palace doesn't apply because it wasn't a shooting of two patrons by an angry patron who'd been ejected. It was, you know, a stabbing by a patron at a table at a similar function. So sometimes, you know, it's one case is distinguished by the facts of the other. But at the end of the day, you know, some of these cases, unfortunately, will sit there for years, and then some clever lawyer will say, oh, there's something from 1932 that we can argue in this particular case. So unfortunately, sometimes the involvement of the common law will change things, but it's a slow process, you know. And causation types of cases very rarely would be allowed to be appealed to the High Court unless the High Court perceives that they're going to change the law. So most cases seem to be determined on their facts and circumstances and the binding precedents in the state courts and territory courts, rather than going all the way up to the High Court. It's a slow process.
Thank you. There's another one here. I'm just going to get closer to read this. Follow-up would be the concerns raised by the Victorian industrial manslaughter legislation. No
concerns. I like it. I like it.
There you go, James.
And the reason why I like it is, and look, you know, there's a number of people in public office who are probably very nervous at the moment because there's 700 and something deaths here associated with COVID, and I suppose, you know, the realities are there has been, I'm well and truly aware of it, there's been a formal approach to WorkSafe Victoria to investigate in the context of industrial manslaughter for really negligent actions by those who had the authority to control the systems that were in place at the hotels. As I said, some of you may have heard me on the ABC a couple of weeks ago, where I said, don't get this wrong. The security guards trying to have sex with a quarantine guest in a hotel is terrible. We all know that, you know, and that's actually, you don't need to be trained about those things. You don't need to be supervised that you don't do those sorts of things. You know, that's common sense. But understand, the guards only work to the system to which they're allowed to work to. So if there's poor levels of induction, training, hygiene, supervision, operating procedures, disciplinary action, monitoring, and all those things that go in place with an operational system, well then who do we blame for that? Do we blame the guard who's on, you know, $20 an hour? Do we blame the security firm that's got millions now through a government contract? Or do we blame those that have approved the systems to go in place, which is higher up? Or is there a number of co-defendants like healthcare, like DHHS, which is the Department of Health and Human Services? Is it other government departments, or is it the security firms, or is it those within the security firms? You know, it's their questions that no doubt will come out and be answered when the report comes out in November, which will probably be December.
Definitely going to be a messy one.
Oh yeah, it'll be ugly. It'll be ugly.
Since I think most people here are consultants, what's the frequency, or is there any cases in recent history of security consultants getting in trouble for giving unreasonable or poor advice?
Not in Australia. Yeah, not in Australia. I touched on it just very briefly at the start. There's one that I actually wrote off, and then I gave that example of McDonald's with their risk assessors, their in-house risk assessors. But there's a number of cases. There's 3 cases in Australia at the moment for poor training, for deficient training, 2 TAFE colleges and 1 private provider. But those providing advice, you know, sometimes the trends of the United States impact upon us. So what occurs in the United States, say 10 years ago or 20 years ago, the trends there become relevant to us here. I can safely say to you, there's a lot of legal research that goes on as to what's the best angle to take. And I mean, you know, I quite often speak at lawyers' conferences, and in particular those involved in, say, you know, the Australian Plaintiff Lawyers Association and similar bodies that are involved very much in personal injuries types of cases. And I quite often talk about, these are the trends that I see in the United States. And I've got a mate that's a retired judge over there who sends me information all the time about, you know, oh, this is an interesting case. Here's a new frontier, etc. So, but there's been none in Australia that I'm aware of yet involving security consultants, but I am aware of medical advice, so medical, legal advice. At one stage, you couldn't sue a lawyer, now you can, for negligent advice and actions. So at the end of the day, other professional areas, accountants get sued all the time, as we know. Financial advisors get sued all the time when their advice turns pear-shaped. But the realities are nothing that I'm aware of at this stage, nothing pending, which is good.
I think as professionals, we must assume that could only potentially happen just around the corner for us. So we should be doing everything that we possibly can do to ensure our advice is as accurate and checked and timely as possible, because it's only a matter of time, in my opinion.
That's correct, Shane. And look, the thing to perhaps acknowledge is the fact that even if the advice is reasonable advice and you've done nothing wrong, you could still end up being a co-defendant somewhere because say the law firm has decided, let's try the scattergun approach, which is very common. If we bring in as many co-defendants as we can, there's a greater chance that they're going to get together and say, all right, you pay 80%, I'll pay 30%, etc. Which is what happened in the David Hooks case, which was back in the 1990s. I did the expert report in that case. And, David Hooks, when he died outside the Beaconsfield Hotel down here in Melbourne, the hotel was sued, the security firm that provided the crowd controllers was sued, and the individual crowd controller who actually struck him and killed and caused his death, he was sued. Now, of course, the individual wouldn't have any money, so they're not really, a key player in civil litigation, but for completeness of pleading, they decided to include his name.
Yep.
But they're really suing. They really
go
suing.
after those with the money.
Correct, yeah. So they're really after the insurance company for the security firm and the insurance company for the hotel. And and effectively, that's what it became. I actually gave evidence in that case as well. And the judge asked me an interesting question, and that was, are they equally liable or not? And I was explaining that, the security firm provided the operational system and the specialist, they have the specialist advice and activity. But the hotel can't escape, because the hotel still says to the security firm, we're prepared to engage only 3. You might want 8, but we're only prepared to engage 3. And we want them for these times. You might want them for longer times, but we only want them for these times. And here are our standards, or here are our expectations. So a hotel can't escape liability in those circumstances, because at the end of the day, they still endorse the system that's in place, but it's a lesser amount. And from memory, it was something like 70%, 30%.
Another question for you.
Sure.
You can see these questions in the thing too. You're probably reading them already. I can't tell by where you're looking.
Too lazy.
On risk appetite, does a high risk acceptance of the defendant affect the definition of reasonable actions?
Well, it does. Yeah, it does. I mean, the realities are, and we know if we look at perhaps workplace health and safety legislation. I mean, we've got Fair Work Australia, but you've got national legislation, but you've still got state legislation sitting down here in Victoria. But certainly there are some occupations that are high risk compared to others, and therefore they need to be treated differently. So I would say, if for example, if I was conducting a risk assessment of, say, cash in transit, where there's guns and money, and people that like money and guns sometimes, the realities are that would be a different, the hazards that you would identify and need to treat might be very different to, say, a person who's working at, say, a shopping centre. Even though there can be risks in shopping centres, there can be armed robberies in shopping centres, but the context of someone driving around in a marked truck that's got heaps of cash in it, you might say there are certain times during that work when they're not fortified in the truck, when they're actually out and about, moving around between various sites, you might say there's some of your major risks. It's interesting. When I was in Victoria Police, I did 17 years, and at one stage I went to an armed robbery. I was in the armed robbery squad for 4 years, and I went to an armed robbery out in Doncaster in the east of Melbourne. And I can still remember, it was a Commonwealth Bank that got held up, and I can still remember the bank manager who said to me, "Sergeant, I've been a bank manager for how many years? I would never have thought we'd have an armed robbery here." And I've looked at him and I've said, "Man, You've got a sign out the front that says bank, and everyone knows there's cash in here. What do you think's going to happen one day? You know, the realities are. So there are some, you know, business operations. There are some activities that you'd say clearly they're higher risk, and those risks need to be treated, and they might be treated very differently based upon the level of risk that's perceived. Can't hear you, Bo.
Test.
There you go. You're back.
There was a second part to that. Sorry. If the entity accepts higher risks, then they would find it reasonable not to treat what they deem as middle or lower risks. And then in a court case, you were saying before about the reasonableness. If one entity has a higher appetite for risk, how does that affect the reasonableness assessment?
Oh, look, each case would be different. I hate saying that, but it's true. Each case is different, but the realities are, you know, by the time a risk assessment might be done, you might say we've got a range of risks. Some are extreme, some are high, some are moderate or medium, and some are low. And at the end of the day, the way that those risks are treated might be something like not dissimilar to, say, the hierarchy of controls under workplace health and safety, where you try and eliminate some you might try and substitute, some you might treat through administrative processes, etc. So the realities are, you know, a good risk assessment, you would think, would identify all those reasonably foreseeable risks and attempt to treat them as best they could in the circumstances. So there'll be a range, of course. They won't all be high and they won't all be low, as we know.
Sorry, I'm just trying to read one Mark's put here, but I'm not sure if he's agreeing. Sorry, Mark, are you agreeing with Shane's comment?
Yeah, I'm not actually asking a question, just making a statement.
It read good, so I'm like, I bet this might have something to it. Well, if anyone's got any more questions,
go ahead, James.
I was just going to say, the one thing to point out is when you're saying about the U.S., the reason that the U.S. ended up having ACES and all the training things that they did, a lot of that was because of liability, to show that people had appropriate training. It's where the CPP and all that came about from, was that so that they could say, well, no, the person we have has appropriate training to do the job, and that is a standard of training that is accepted across a wide body of the industry.
Yeah, it's correct. I don't disagree with that at all. That's certainly, when you look at the historical stuff associated with the development of ASIS back in the 50s, you see quite clearly how there was this need that was perceived. And of course, you know, it's just grown and grown and networked appropriately globally. But certainly, as we know, the litigious mad Americans, something had to be done to try and mitigate the risk.
I don't think it's that really, when it comes to litigious, it's not that much different here. People just haven't picked up that they can go after professional advice. They go after accountants, they go after large firms, but they haven't gone after individuals. Mainly, I think, because probably they don't see money in it, but they will soon. Once someone will pick it up, something will go pear-shaped. Someone will decide to go for it for compensation, and you wait, it'll go gangbusters.
And that's correct. And can I say to you, well, to all of you, but in particular, can I say there wouldn't be a case that I've been involved in where I haven't asked the question, you know, in addition to what was the system that was in place, the next question is, who developed the system? What was their competency, and how did it all evolve? You know, and the realities are, just because lawyers approach me doesn't mean I'm going to take a case on, because quite often I'll say, you know what, I don't think you've got anything here, or I wouldn't support that particular case. So sometimes I'll walk away, but the realities are, you know, that is a question I ask. Who put the system in place? How did it evolve? What's the organisation done in the last 10 years about this system they've had in place for 50 years? And of course there will be improvements and changes, because there'll be legislative requirements, sometimes there's regulatory requirements that need to be put in place. But the realities are, as you rightly say, you know, it'll happen, and it's probably closer than what we realise. Even if you haven't done it.
Another question, sorry.
It was just more of a statement, Tony, regarding your comment around an increase in domestic violence incidents that are now happening, also transitioning away from the domicile into the workplace. That's something that we have definitely seen in our consultations with clients that are concerned about that sort of thing in the commercial sector just this year, in fact. So yes. We previously would cover off violence in the workplace, under physical assault or, some other line item in the risk register. But we're seeing a number of clients now very much concerned under heightened stress working environments, people working from home, so the blurring between, home life and work life, where we are seeing increased risk items now coming to the fore in the workplace that employers never had to be too concerned about, and various incidents with clients this year where they've had aggrieved members and their significant others, creating security situations in the lobbies or in the reception areas of their offices, and them they never having dealt with those circumstances before.
Quite true. And it's interesting, if you look at the WorkSafe or the safe work materials that are now circulating around Australia, domestic violence or family-related violence is something that's, that is becoming more prominent, as you rightly say. And I mean, if you went back 10 years ago, you wouldn't see the same approach to what there is now. And of course, that broadness of taking that into account, especially when you've got larger workforces or you've got isolated workers. I mean, there's in the healthcare area in particular, and the support services, there's plenty of people out there going one up, isolated to a home to provide a service, and it might be a health service, it might be Meals on Wheels, and all of a sudden, you've got someone who's being chased down the street or someone who's been seriously assaulted. And it's interesting. I did developed a strategy for a multinational, and they provide government support services and maintenance in Australia and New Zealand, but also in other areas. But they're the two countries that I travelled to. And, you hear some horrific stories that occur in public housing estates or in supported public housing in residential areas where, someone's full of the local chemical and they smash up the toilets. And of course, they've got to have operating toilets or workable toilets. So you've got this poor tradesman who goes there, who's got no idea he's a tradie. And next minute he's knocking on the door, and next minute someone's got him assaulted, and that's the reason why this particular job came around. But of course, when you're speaking to some of the workers, and some of these tradies are saying, "Oh, don't worry about it, mate. I've got my hammer. I'll sort it out." And you're thinking, you can't hit someone over the head with a hammer. It's got to, the system has to be a better system than that. It's got to be some level of awareness and risk assessment before you even go near these places. So these sorts of, these evolving risks are risks that are becoming more prominent these days, whether it's just an increase in, lack of tolerance generally, or whether it's greater substances out there or more accessible substances, who knows, and mental health too, of course.
Yeah.
Some of us run businesses in prisons, where we end up in psychiatric wards, where we end up in emergency wards. And a lot of our security work is in places where other people don't want to be, including overseas in places where there's no risk. And we're running businesses and sending employees there.
Yeah, it's quite true. Quite true. I mean, it's really, the work of the security consultant / risk assessor is really, it's quite often you've got to be very innovative and think on your feet. Sometimes thinking in the abstract about what can go wrong or what are the risks, and then how does that risk evolve into something else that may be a greater risk. And I know some of the work that some of the specialists that are up in, say, New Guinea or up in Christmas Island or wherever they may be, but they're offshore. Some of the stuff that they have to cope with, and you think with limited resources sometimes, and sometimes inaccessible training or appropriate training leads to all sorts of problems, as we know. Yeah, but you're right. Sometimes others don't want to do it.
If that's all the questions, just want to say thank you so much, Tony, for your time tonight and giving the presentation. Thanks also to everyone from Victoria. Hope you're all doing okay with level 3 or 4, wherever you're up to, and come out of that soon.
We're still on
Thanks
stage.
everyone for your
Just so you know, I don't know who's guilty of this, but I've got 12 texts sitting here on my phone, and they're all insulting.
Must be Victorians.
Correct. I'll blame them anyway.
All right. Thank you very much, everyone.
Thank you
Thanks
very
very
much.
much,
That was
Tony.
excellent.
Great
Thank you for
presentation.
presenting.
Great. Thank you. All the best.